Seek an answer.
Ladies and gentlemen, we commence. Fortune shines on us today because both teams have won so far, and each team is representing the team it wishes to represent, which is good fortune indeed. And so today, the tribunal, which I have the honor of presiding, will listen to the arguments from the two winning teams, and we commence with the claimants on questions of procedure.
Mr. Presiding Arbitrator, the parties have agreed that respondent shall go off first on the procedural aspects, followed by claimant, and then claimant shall start off on the merits of the case, followed by respondent, and we reserve 14 minutes per submission and reserve 1 minute for the rebuttals and the surrebuttals. Thank you.
A few introductory remarks, if you please. If this were a real arbitration, it would take a bit longer than it will take today. So we are not really evaluating substantive winning or losing on this case. We are looking at your presentations. It does happen that some people are wonderful in terms of presentations, and as the case goes on day after day, it turns out that somebody who wasn't quite as electrifying is very good on substance. We don't have the time to go into that sort of thing today, so this will be vis-a-vis the arbitrators, something akin to speed dating, but that's the way it goes. We don't care at all about the outcome of this case, even less than an actual arbitral tribunal. It's not the point of the exercise. We want to examine how far you have already in your courses assimilated the tools of the trade, which you will now be exposing to us, and you begin.
Certainly, Mr. Presiding Arbitrator. Mr. Presiding Arbitrator, members of this tribunal, and esteemed colleagues. My name is Sara Sharaf Ali, and on behalf of claimants, Orcus Worldwide, I'll be presenting the procedural aspects while my co-counsel will tackle the merits of this case. Members of this tribunal, we are here today because respondent was neither committed to the sales agreement, nor is it now committed to resolving the ensuing dispute. As a successor to the Botanical Gardens, respondent assured claimant that it was committed to its predecessor's agreement, including the dispute resolution clause. In order to gain access to claimant's confidential arbitration tactics, respondent is deliberately misinterpreting the dispute resolution clause to apply the SIAC Rules 2025. In this vein, we have two submissions to make. That first, the tribunal should apply the 2016 version of the SIAC rules. And second, the tribunal should not order the disclosure of claimants' funding agreements. Starting with my first submission, that the tribunal should apply the 2016 version of the SIAC rules. Members of this tribunal, in an attempt to gain an undue advantage, respondent asserts that the proceedings were initiated on the basis of the wrong set of the SIAC rules. However, any sensible interpretation of the dispute resolution clause leads to the conclusion that the SIAC Rules 2016 should apply to these proceedings. Here we advance two arguments. That first, according to the wording of the dispute resolution clause, the 2016 rules should apply. And second, in any case, the 2016 rules were prevailing at the time of the commencement of the mediation proceedings. Starting with the first argument, if the members of the tribunal could please follow me to page 13 of the record, which is the sales agreement signed by the parties. The clause titled Dispute Resolution states, and I quote, "Any dispute arising out of or in connection with this contract, including any question regarding its existence, validity, or termination, shall be referred to and finally resolved by arbitration administered by the Singapore International Arbitration Center in accordance with the current arbitration rules. End of quote. Members of this tribunal, the point in contention here is the term current. As it was clarified in Procedural Order Number 1, the CISG applies to the arbitration agreement and thus to its rules on interpretation. According to Article 8(1) of the CISG, the party statements should be interpreted according to the subjective intent test. And in the alternative, according to Article 8(2) of the CISG, the understanding of a reasonable third person in the same circumstances. Here we submit that it is difficult to determine the actual intention of the parties, therefore we should move to the reasonable third person test while considering all the relevant circumstances by virtue of Article 8(3) of the CISG. Starting with the negotiation history of the arbitration clause. The Botanical Garden, which is respondent's predecessor, demonstrated its intent of applying the 2016 version of the SIAC rules by deviating from the SIAC model clause. Initially, the model clause states, and I quote, "For the time being enforced, which rules are deemed to be incorporated," end of quote. In the Singapore High Court case of Cars and Cars in 2009, ruled that the wording of the SIAC model clause, "for the time being enforced," is a dynamic reference, which refers to the time of the commencement of arbitration. In the present case, the parties deliberately amended the phrase for the time being enforced to in accordance with the current arbitration rules. If the members of the tribunal could please follow me to page 21 of the record, which is Exhibit C7. This is an email sent from the Botanical Gardens Chief Contracting Officer to claimant's CEO. And I would like to quote the second line that starts with "I follow," and I quote, "I followed your suggestion and had a look at the arbitration rules of the Singapore International Arbitration Center. The current version of their arbitration rules with the AMA protocol is acceptable to us," end of quote. Now, if the members of the tribunal could please follow me to page 56 of the record, which is Procedural Order Number 2. Specifically, clarification 7, starting from the third line from the bottom. Starting with states, and I quote, "Ms. Gobley also added a reference to the current arbitration rules, which were the ones that she had read," end of quote. Members of this tribunal, the current rules that Ms. Gobley had referred to in her email, as well as in the dispute resolution clause, were the 2016 rules. Therefore, they should be applicable to the case at hand. Moreover, respondent cannot claim unawareness of this intent. As first, respondent had the access to the negotiation histories between claimants and the Botanical Gardens. Moreover, the dispute resolution clause required board approval from the Botanical Gardens board, which Mr. Albis, which is respondent's head of Spice Line, was a part of at that time. Furthermore, the parties amended the quantity and the delivery terms of the contract itself. However, they left the arbitration agreements untouched. And in any case, as a well-advised business person, respondent should have noticed the change from the model clause and have raised its suspicions if it had deemed there was any.
A question. Did the parties stumble into an ambiguity, or is there a right reading and a wrong reading?
Mr. Presiding Arbitrator, if there was an ambiguity, it should be interpreted against respondent, as it was respondent's predecessor that drafted this dispute resolution clause.
Well, that's how to resolve an ambiguity which is admitted as such. So you do?
Yes, Mr. Presiding Arbitrator.
Right.
My apologies. I would like to correct myself. There is no ambiguity in the case at hand, and we submit that the term current does refer unambiguously to the 2016 rules. Moving on to our second argument, that even if the tribunal were to find that the parties did not agree on a static reference, then the proceedings commenced with mediation on 19 December 2024. Members of this tribunal, the dispute resolution clause was based on the ARB-Med-R protocol, under which arbitration and mediation are considered to be part of a single procedure. By modifying the AMA clause to a mediation and arbitration clause, the parties intended for mediation to be treated as the commencement of arbitration. After claimant proposed arbitration under the SIAC rules, Ms. Gobley confirmed that board approval would only be given under the condition that the first step of the dispute resolution proceedings should be mediation. And a board member suggested skipping the first step of having to file a notice of arbitration for the idea of enhanced efficiency. In any case, Ms. Gobley highlighted it in her email of Exhibit C7 that, if the members of the tribunal could please follow me to page 21. The fifth line from the bottom states, and I quote, "The initiation of the mediation proceedings should be treated for the purpose of the statute of limitation as constituting the commencement of arbitration proceedings." End of quote. Moreover, through the use of the amended ARB-Med-R protocol, the parties intended for any settlement that was reached in mediation to be turned into a consent award in the arbitral step. In light of these facts, the parties agreed on a multi-step single dispute resolution process where the date of the commencement of mediation should be considered the date of commencing arbitration. In the case at hand, claimant initiated mediation on 19 December 2024 and thereby commencing the arbitral proceedings under the 2016 SIAC rules. Moving on to my second submission.
So, to conclude on that, is your submission then that somehow the parties have agreed that Equatorianian law, the arbitration agreement is modified as compared to the SIAC rules initially?
Yes, Mr. Presiding Officer, the parties did agree to apply the AMA protocol from the SIAC rules. However, they adopted a modified version of this protocol, which was to skip the first step of arbitration.
So we have a different arbitration agreement than if we had simply agreed to the SIAC rules.
Precisely,
Yes.
Mr. Presiding.
Right. Second.
Moving on to the second submission, that the tribunal should not order the disclosure of claimant's funding agreements. Members of this tribunal, respondent wants to hinder claimant from effectively presenting its claim by requesting the disclosure of its funding agreements, both with Litshore and its adverse cost insurance agreement with ATG funding and the adverse cost insurance with Litshore. In this vein, we advance two arguments. That first, the tribunal does not have the power to order the disclosure of the funding agreements. And second, the tribunal should not order the disclosure of the agreements. Before starting with the first argument, as a preliminary matter, claimant likes to submit that ATE insurance agreements are not third-party funding agreements, as the relationship with Litshore does not constitute as Litshore having a direct economic interest in the proceedings. Moving on to the first argument, that under the 2016 rules, the tribunal does not have the explicit power to order the disclosure of the funding agreements. The tribunal also does not have an implicit power to order the disclosure of both the funding and the insurance agreements. If the members of the tribunal could please follow me to page 59 of the record, which is procedural order number 2. Page number.
Well, excuse me, will the tribunal have no competence to lay the reason for disclosure on Article 27 of SIAC rules of 2016?
I believe Mr. Arbitrator is referring to the document production powers of the tribunal, which is under 27F of the SIAC rules. And here we submit that such documents should only they were relevant to the case and material to its outcome. And we submit that the documents in question are not relevant to the case or material to its outcome, as they do not have relevance on whether or not respondent should be excused under Article 79 of the CISG, or whether claimant was entitled to do the cover sale under Article 75 of the CISG, which my co-counsel will dive into further in her submissions. Now, if the members of the tribunal could please follow me to page 59 of the record, which is procedural order number 2.
59.
Yes, Mr. Presiding.
Procedure order number 1. Sit down.
Before some additional time to touch up on my to continue this clarification and touch up on my second argument.
You're not at 14 yet, but you're approaching it with great speed.
So I would like to refer to clarification number 36, which states, and I quote, 2016 SIAC rule in Janubia allowed a tribunal to compel the disclosure of a third party funder. And the answer continues on the second page, which states, no, it upheld the SIAC award 2016 rules in 2020, where the sole arbitrator rejected a request to order the disclosure of a funding agreement due to the lack of required powers, end of quote. I would like to highlight the fact that this decision was made in 2020 after the SIAC 2017 practice note was issued, and even under the 2017 practice note, the tribunal found that they did not have the power to order the disclosure.
We have no knowledge of the circumstances of that case.
Certainly, Mr. Arbitrator. And here we submit that even under the 2017 practice note, the disclosure is limited to the existence and the identity of the funder, which in the case at hand, claimant in good faith has disclosed the existence and identity of the funder's identity. Moving on to the second argument, if I could request an additional minute from the tribunal to address it.
Yeah.
Thank you. Now, even if the tribunal were to find that the 2016 rules apply to the case at hand, we submit that the tribunal should not order the disclosure for the following reasons. As first, the interest in requesting a security for cost application does not constitute as a compelling ground, as claimant has contacted with Litshore and obtained an after the event insurance in order to negate the risk of respondent not receiving a payment if an alleged adverse cost was to be applied to claimants. Moreover, an alleged influence on the proceedings does not constitute as a compelling ground, as was clarified in the case at hand in procedural order number 2. There are no settlement threshold applied by ATJ funding in the funding agreements. To conclude my submissions, members of this tribunal, we submit that the 2016 rules should apply to the case at hand, and that the tribunal cannot and should not order the disclosure of claimants' funding agreements. And with that, I conclude my submissions. Thank you.
Thank you.
Excuse me, don't you think that in the light of the existence of Article 38 of SIAC 2025, don't you think that will affect the Supreme Court, or which issued the first precedent and limitation of the tribunal authority and order and disclosure? Don't you think this will affect the court when it realized the intention of SIAC rules maker?
Mr. Arbitrator, it could affect those cases that are initiated under the 2025 rules. And we submit that even if the 2025 rules were to apply, then under Article 38, the tribunal should only order the disclosure as it sees fit after looking at the party's submission. And we state that after looking at the party's statements, the tribunal should not order the disclosure as respondent does not have a compelling ground or demonstrate the need for necessity in this case at hand. Thank you.
Mrs. Saad.
Thank you, Mr. Presiding Arbitrator. Honorable members of this tribunal, opposing counsel, good morning. My name is Jad Saad, and I, alongside my co-counsel, Tea Daboul, represent Darwin Natural Food PLC, respondent in these proceedings. Members of this tribunal, allow me to briefly present the facts on this case. A contract was concluded between claimant and respondent for the sale of orchids, which included a dispute resolution clause providing for mediation and then arbitration. A dispute arose regarding the performance of this contract between claimant and respondent, which will be further elaborated by my co-counsel on the merits. Consequently, claimant initiated mediation on the 19th of December of 2024. Following its failure, claimant initiated arbitration 2 months later on 31st of July of 2025. In light of this, we will be making 2 submissions on the procedural aspects of this dispute, mirroring my opposing counsel's outline. First, and this will be divided into 2 main arguments, is that this tribunal should apply the 2025 SIAC rules. And second, which will also be divided into 2 main arguments, is that this tribunal should order the disclosure of the third-party funding agreement and the ATE insurance. Starting with our first submission, our position is that this tribunal should apply the 2025 SIAC rules as the parties have agreed on those set of rules. To support this position, we will first demonstrate that the interpretation of the arbitration agreement compels the application of the 2025 SIAC rules, and subsidiarily that the proceedings commenced with the commencement of arbitration in 2025. According to Article 8 of the CISG, to interpret the arbitration agreement, one should rely on a party's intent where that party knew or could not have been unaware what that intent was, or otherwise interpreted according to the understanding a reasonable person would give it. Members of this tribunal, the record speaks for itself. If I may please refer the tribunal to page 13 of the problem. Clause 15, which is the dispute resolution clause.
The first.
May I know if the tribunal is following?
Yes.
It is stated in line. Excuse me. No, Mr. Arbitrator, page 13.
13.
Yes. Page 13, clause 15.
Yes.
It is stated in line 4 from the beginning that any dispute shall be resolved by arbitration administered by the SIAC in accordance with the current arbitration rules of the SIAC. Starting with the subjective intent. Claimant mentions pre-contractual negotiations between the parties. However, claimant did conclude a new contract and cannot, therefore, base its argument on pre-contractual negotiations that cannot be applicable. In this regard, we move on to the objective interpretation. Members of the tribunal, it is respondent's position that words needs to be given their proper weight. A reasonable person would understand the term current as the latest version of the SIAC rules in effect at the date of the commencement of the arbitration proceedings.
Why couldn't an innocent party read it as the then current?
Could you rephrase your question, Mr. Presiding Arbitrator?
Why couldn't an innocent party read the clause with the current arbitration rules as suggesting in accordance with the then current?
Indeed, Mr. Presiding Arbitrator, the word current could have 2 different meanings. It could refer to the time of the commencement of the arbitration proceedings, and it could refer to the time of the conclusion of the contract. It is, however, respondent's position, and we back our claim by case law that the term current used in our case refers to the 2025 SIAC rule. To back my claim,
So
cars.
you need to back it.
Yes.
That's what you're saying.
Yes.
Okay.
This is backed by a case rendered by the Singapore High Court, Cars and Cars versus Volkswagen in 2009, that mentioned that if the parties wanted to choose a set of rules that are not existent at the time of the proceedings, then they should mention them explicitly. This dispute was between the applicability of the SIAC rules 1997 and 2007. Claimant mentioned in the contract the Incoterms of 2020. So why not mention the SIAC rules of 2016 if they wanted to apply them?
Oh, excuse me, what about the linguistic meaning of current in time?
Yes, Mr. Arbitrator, the term current can have two meanings. It can refer to current as in the conclusion of the contract, and it can refer as current as in the commencement of the arbitration proceedings. However, case law is very clear. If parties wanted to apply a set of rules not existent at the time of the arbitration proceedings, then they should mention them by name and by date if necessary. In our case, claimant failed to do so in the contract while mentioning the Incoterms 2020. Respondent further submits that the proceedings did not commence with mediation. Mediation only began on 19th of December 2024 and ended in July of 2025. Arbitration only commenced on 31st of July when the notice of arbitration was filed and confirmed by the SIAC registrar. Members of this tribunal, the rules are clearly on respondent's side, as the SIAC rules of 2025, notably Article 6.2, clearly states that the date on which the notice is received by the registrar shall be deemed the date of the commencement of arbitration, a rule that finds its equivalent under Article 3.3 of the 2016 SIAC rules. It was also very recently held in 2025 by the Singapore High Court in DMZ versus DNA that the parties to SIAC arbitrations waive their right to appeal on decisions of the registrar under Article 40.2 of the 2016 SIAC rules and 63.4 of 2025 SIAC rules. Furthermore, and if you turn again to the same page, 13, clause 15, in line 6 from the bottom, it is expressly provided, and I quote, that the parties further agree that at the first step of the dispute resolution process, they will attempt in good faith to resolve the dispute through mediation at the SIMC. End quote. Respondent submits that words must be given their proper weight. In the present case, the arbitration agreement deliberately refers to a dispute resolution process rather than an arbitration process. This linguistic choice is decisive. It confirms that mediation cannot be subsumed within arbitration, but stands as a preliminary and a distinct step. If the tribunal has no questions, I will be moving on to my second submission.
Requirement of disclosure.
Yes.
Okay.
Moving on to my second submission. Respondent.
Time is fleeting.
Thank you. Respondent submits that this tribunal has the power to order disclosure of the third-party agreement and should order the disclosure of the third-party funding agreement.
But must not do it. It is not a position that it must do it.
The tribunal has a discretionary power in this regard. To begin with, and pursuant to Article 38.4 of the 2025 SIAC rules, it is clearly mentioned that the tribunal can order the disclosure of the details of the agreement or the agreement itself if it sees it fit.
Let's skip a bit. The claimant lacks funding for a major international arbitration. Major or not, lacks funding for the arbitration. It goes to a friendly bank, which is friendly and doesn't require a lot of security. Is that a third-party funding agreement?
Well, Mr. Presiding Arbitrator, under the SIARB guidelines, third-party funding is defined as a contractual arrangement in which an external entity finances some or all parties' legal fees and expenses to pursue or defend it in a claim. And under the SIAC 2025 rules, a third-party funder needs to have a certain economic interest in this
Okay.
regard.
So forget that example. Our investor has a wealthy uncle who says, I think you have a good case. I think you've been very badly treated by those people. I'll help you. He's very rich. But it's just the uncle. It's not the investor himself. He says, here, I'll give you $1 million. And his nephew says, I'm not sure that will be enough. He says, we'll see. What needs to be disclosed, if anything?
If the funder has an economic interest in this regard,
I
then
just told you the situation.
yes, then it should be considered as a third-party funding.
He didn't say anything about paying back.
May you please rephrase your example?
Said, I have this good claim. And the uncle said, I'm really sorry that these people are treating you so badly. I'll help you. Here's $1 million. And the nephew says, well, I'm not even sure that will be enough. He says, we'll see what happens. I'll help you. Does that need to be disclosed?
This does not need to be disclosed.
Sorry?
This does not need to be disclosed.
Okay, so you require the stake.
Yes, there needs to be an interest in the case.
Okay, carry on.
Thank you. Respondent contends that under the 2025 SIAC rules, the tribunal has the power and should order disclosure of the third-party funding agreement. Respondent acknowledges that an order for disclosure of the third-party funding agreement should be a measure only granted when the necessity and proportionality conditions are met in light of the circumstances of the case. An exit tribunal held that a disclosure would be relevant where a party is insolvent or where there's the risk that this party might not have sufficient funds to pay any potential adverse cost award. In this vein, Professor Bourne stated that interpretation of investment cases can guide tribunals in commercial cases, as it is established that arbitral tribunals draw inspiration from one another to solve similar procedural problems. In our case, both conditions of necessity and proportionality are met. Firstly, claimant did not disclose any information guaranteeing the payment of any potential adverse cost award and appears to be facing insolvency, as mentioned in the PO2, page 58 of the problem, paragraph 20. Moreover, and despite the negotiations that have taken place and claimant's desperate call to try and arrange a new sale of vanilla orchids, the outcome remains uncertain, which justifies such disclosure. Concerning the proportionality conditions, and if I may please refer the tribunal to page 58 of the record. In paragraph 26, where it is mentioned that the funding agreement does not expressly describe any arbitration strategy. It is therefore respondent's position that disclosure would not be a disproportionate measure, as no arbitration strategy will be revealed and the necessity condition is met. Moreover, claimant mentioned the decision rendered by the Supreme Court of Danubia that upheld a SIAC award under the 2016 rules, which stated that the tribunal does not have the power to order third-party funding agreement. Respondent's position, and may I please ask the tribunal for an extra minute to...
1 minute.
Thank you. Respondent's position is that it is true that Danubia is a common law jurisdiction. However, for this decision to be a binding precedent, the decision needs to be similar to the context of the case and the facts of the case. In our case, we do not have information about the decision rendered by the Supreme Court of Danubia and therefore cannot consider it as a binding precedent. Moreover, claimant rightfully mentioned Article 27F of the 2016 SIAC rules, which grants the tribunal such power. Accordingly, the tribunal has the authority under the 2016 SIAC rules to order the disclosure of the third-party funding agreement by applying the conditions equivalent to those developed under the 2025 SIAC rules. To conclude, respondent respectfully submits the tribunal to apply the 2016 SIAC rules and to disclose the third-party funding agreement.
Thank you.
If the tribunal has no further questions, then this concludes my
Thank you.
submission.
We move to rebuttal.
Members of this tribunal, opposing counsel mentioned that there are no express strategies contained in the funding agreements. However,
Are you being recorded? It works? Okay, sorry. Carry on.
there are no express strategies included in the funding agreements. However, we submit that there are indeed implicit strategies, such as the funder's internal assessment of claimant's merits that could give respondent an insight to claimant's arbitration strategy. Thank you.
Very good.
Respondent's position is that even though implicit arbitration strategies would be present, there is a necessity to order such disclosure due to the fact of claimant's alleged claimant's insolvency and because claimant is facing insolvency.
Thank you. You understood? Yes. All right. You have the floor. Ms. Saif? Yes.
Mr. Presiding Arbitrator, members of this tribunal, and esteemed colleagues, good afternoon. As previously introduced by my co-counsel, my name is Latifa Saif, and I hereby represent claimants Orcus worldwide in today's proceedings. Respected members of this tribunal, in a desperate attempt to escape liability, respondent relies on a foreseeable risk in the spice business. However, respondent's failure to perform is the result of a strategic choice laying with its sphere of control. Respondents not only failed to honor its commitments, it now relies on a formalistic understanding of Article 75 CISG to undermine claimants' damage claims. In this vein, claimants have two submissions to make. That's first, respondent is not exempt from liability pursuant to Article 79 CISG. And second, claimant is entitled to claim and prove damages pursuant to Article 75 CISG. Starting off with our first submission, that respondent is not exempt from liability pursuant to Article 79 CISG. According to Article 79 CISG 1, it says, and I quote, "A party is not liable for a failure to perform any of his obligations if he proves that the failure was due to an impediment beyond his control and that he could not reasonably be expected to have taken the impediment into account at the time of the conclusion of the contract, or to have avoided or overcome it or its consequences." We here submit that the requirements under Article 79 1 CISG are cumulative. So if one of these requirements are not met, respondents cannot be exempt from liability. Furthermore, we here submit that the requirements are not met in the case at hand, taking into account that first, the inability to obtain the...
Can I ask you which of these cumulative requirements is not satisfied?
It's our submission that none of these three requirements are satisfied in the case at hand. As first, the inability to obtain the import permits because of the inclusion of the vanilla orchids into Appendix 1 did not hinder respondents from performance. The permit was not a requirement to accept delivery under the sales agreements. Moreover, as the opposing counsel procedural speaker had stated that the parties agreed on the FCA Incoterms of 2020, and the parties agreed that the delivery place is going to be the International Airport of Mediterranean. In line with Article A2 of the FCA, delivery would have been completed if claimants made the vanilla orchids available in the international airports of Mediterranean. So members of this tribunal, the import permit was not required from respondents to accept or to take the delivery from Mediterranean. Alternatively, members of this tribunal, the impediment was actually foreseeable at the time of the conclusion of the contracts. If I might guide the tribunals to page number 10 of the record, which is the sales agreement that was concluded between the parties. Under clause number 1.1, which is the definition, the sentence that starts with CITES, and I quote, CITES means the Convention of International Trade in Endangered Species of Wild Fauna and Flora as amended from time to time, end of quote. And this indicates, members of this tribunal, any reasonable person pursuant to Article 82 CISG, by reading the sales agreements, would understand that the impediments was actually foreseeable at the time of the conclusion of the contracts, and taking into account that the vanilla orchids are sensitive and rare species, so the inclusion might happen at any time possible. Moreover, it was clarified in the case at hand that in a comparable case in Equatoriania, there was a plant that had been moved to Appendix 1. So we here submit that the inclusion was actually foreseeable at the time of the conclusion of the contract. Alternatively, members of this tribunal, the impediments and its consequences were avoidable. And we here advance 2 points. First, the impediments could have been avoided if respondents accepted an earlier delivery. We acknowledge the fact that was clarified in the case at hand that accepting an earlier delivery would be costly. However, according to Professor Spencer in her 5th edition book, she states, and I quote, Article 79(1) CISG requires that the breaching party should take the necessary measures to overcome the impediments, even if that results in a higher cost, end of quotes. At the very least, members of this tribunal, respondents should have accepted an early partial delivery, as one of the 3 greenhouses were already ready in January 2024. Moving on to the second point, that respondents promised our clients that they would apply for permits in November 2023, yet respondents failed to do so. In any case, members of this tribunal, respondent is stopped from relying on Article 79(1) CISG. Respondents' subsequent conduct and statements indicates that they would fulfill their contractual obligations even if the inclusion or an impediment happened. Moreover, claimants approach respondents multiple times, and on every step, respondents assured that they would apply for permits if it's become necessary.
Can I ask you, at what point did this alleged impediment become forcible for you?
Well, Mr. Arbitrator, to answer your question, we see that in our position that the impediment was foreseeable at the time of the conclusion of the contract. As I have stated in my submission, that in the sales agreement itself, it states that CITES convention can be amended from time to time. So it was foreseeable for respondents to indicate that the impediments might occur at any time. To continue, members of this tribunal, respondents' reliance was reasonable due to my apologies. I'd like to correct myself. Claimants' reliance on respondents' statements and conduct is reasonable. That's why respondents cannot rely on Article 79(1) CISG to be exempt from liability. Moving on to our second submission, that claimant is entitled to damages in the amount of 3.3 million. And this is according to...
Do you agree that the party's decision of CIT of sites is impediment, or you don't agree to that?
Well, Mr. Arbitrator, The requ-
Impediment, or it is not.
Well, it is impediment, and I'd like to clarify on that. First of all, the requirements under Article 79 CISG is that the impediments must be foreseeable at the time of the conclusion of the contract. We acknowledge the fact that the Planties Committees was after the conclusion of the contract, which was on September 2023. We here submit that respondents should have taken the reasonable measures because the impediment was actually foreseeable at the time of the conclusion of the contract. To move on to our second submission, before diving into my submission, claimants would like to clarify what it is entitled of under the sales agreements. If respondent had fulfilled its contractual obligations, claimant would have earned $6.6 million. As a seller, claimant has the authority to determine the exact number of vanilla orchids. If the members of the tribunal could please follow me to page number 56 of the record, which is procedure order number 2. Yes, procedure order number 2, page number 56. Paragraph number 9. The question states, and I quote, in the provision plus and minus 10% regularly used by claimants or in the industry? And the answer was yes. Claimants uses the formula in the contracts involving more than 2,000 orchids to allow flexibility in case of unforeseen fluctuation in the quantity of the vanilla orchids for delivery due to extraordinary losses, end quotes. And this indicates members of this tribunal, claimants has the authority to determine the exact number of vanilla orchids. Moreover, respondents argues that they have the authority to determine the exact number of vanilla orchids, as respondent is responsible for the transportation. However, in the record itself, respondents admits that for a contract for transportation, it should be concluded in between 4 to 6 months before the delivery date. In the case at hand, respondents did not raise any objections that they want to amend the quantity of the vanilla orchids. Hence, members of this tribunal, claimants is entitled under the sales agreement to $6.6 million. Coming back to my arguments, claimant is entitled to damages pursuant to Article 75 CISG, as the sale that occurred in 15 February 2024 constitutes a cover sale pursuant to Article 75 CISG. Article 75 CISG states, and I quote, if the contract is avoided and in a reasonable manner and within a reasonable time after avoidance, the seller has resold the goods, the party claiming damages may recover the difference between the contract price and the price in the substitute transaction, end of quote. Members of this tribunal, we acknowledge that the wording of Article 75 CISG states after avoidance. However, according to Professor Schwenzer in her 5th edition book, she stated that Article 77 should be applicable in a case-by-case analysis. In the case at hand, respondent's statement and conduct indicates that they won't perform the contract. So because claimants acted in a business person, they mitigated the loss and they entered into a valid substitute transaction on 15 February 2024.
You will agree that a case-by-case analysis does not do away with the need to give effect to words as written.
Mr. Presiding Arbitrator, if you could please rephrase the question.
I expect you would have to agree that a case-by-case analysis does not free you from the obligation to be faithful to the words as written.
Well, Mr. Presiding Arbitrator, if I understand your question correctly, is that in case-by-case analysis is not applicable at all times?
No. If you're faced with explicit wording, I expect you would agree that a case-by-case analysis doesn't change that.
Well, Mr. Presiding Arbitrator, it's our position that in the case at hand, based on the fact of the case, respondents' subsequent conduct and statement indicated that they won't be able to fulfill the contract. That's why claimants entered into a substitute transaction in order to mitigate the losses.
Okay.
Why does this respondent's actions or conducts amount to a fundamental breach under the Article 25 more than actually a temporary impediment?
To answer your question, can I ask for an extra 1 minute?
Yes?
Thank you. Where we here submit that in the case at hand, it's a fundamental breach. My apologies, Mr. Arbitrator. Can you please repeat the question?
My question is that why it's considered a fundamental breach under the Article of 25 rather than a temporary impediment?
Where we here submit that it is actually it's not an impediment under Article 79 CISG, and it's not an fundamental breach. To conclude, members of this tribunal, claimants would like to restate its position. That's first, respondent is not exempt from liability pursuant to Article 79 CISG. And second, claimants can prove and claim damages pursuant to Article 75 CISG. This concludes my submission, and thank you.
Thank you very much. Ms. Daboul?
Thank you, Mr. Presiding Arbitrator. First, I would like to ask if, for the purposes of fairness, I could get the same amount allocated to my opposing counsel.
That sounds fair.
Thank you. Mr. Presiding Arbitrator, members of the tribunal, opposing counsel, good afternoon. As my co-counsel introduced me, my name is Thea Daboul, and I will be addressing the merits aspects of this issue. We are here today to discuss a claim that is as legally unfounded as it is commercially disproportionate. Claimant seeks to penalize respondent for a failure to perform that was dictated by circumstances entirely beyond its control, and for a loss that claimant itself exacerbated through a hasty and unreasonable resale, fully expecting respondent to foot the bill. Today's pleading will be divided into two main submissions. I will mirror opposing counsel's outline. First, we will demonstrate that respondent is exempted from liability under Article 79 of the CISG and Clause 12 of the contract. Second, should the tribunal find that there is no impediment, we will demonstrate that Article 75 is inapplicable as its conditions are not met. I will turn to the first submission, mainly that respondent should be exempted from liability under Article 79 of the CISG. All three conditions of the impediment are met in the present case. The impediment was beyond respondent's control, unforeseeable, and unavoidable. First, the impediment was beyond respondent's control. Claimant mentioned the Incoterms. However, the CISG Advisory Council Opinion number 20, which is the highest persuasive authority in the CISG, concurs that despite the inclusion of the Incoterms in a contract, a party can showcase that performance has been affected by an impediment if it meets the conditions of Article 79 of the CISG, as is the case at hand. Claimant also mentioned that respondent did not need an import permit to obtain delivery in Mediterranean. However, it would not be reasonable to expect respondent to take delivery of the vanilla orchids in Mediterranean when the vanilla orchids could not enter Equatoriana because an import permit was required for their entry. Respondent would have had to pay $6 million for nothing. Second, state intervention is a classic external impediment.
How nothing?
Because respondent would not have been able to use the vanilla orchids since the vanilla orchids could not enter into Equatoriana. So the vanilla orchids would have stayed in Mediterraneo.
It happens.
It would not be reasonable for respondent to pay $6 million and
Okay.
not and be deprived of and have the contract be deprived of its substance. Usually, to conclude in a contract, in a sales contract, there are counterbalancing advantages.
That takes you back to the contract.
Sorry?
That takes you back to the contract.
Yes.
People do sign contracts which they regret later.
I couldn't hear the question.
People do tend to sign contracts quite often, which is why we have arbitrations, which they regret later on.
True, but in this case, it was not just that respondent would have had to pay more to take in the vanilla orchids.
Yes.
It would not be able to benefit from its obligation, while claimant would benefit from the $6 million.
So we're back to the contract.
Yes.
Well, excuse me, didn't the respondent have enough time from the sign of the danger by the parties resolution, the impediment itself? There was enough time from the signs that the plant committee decision to the date of resolution of the parties. It was enough time for the respondent to mitigate by earlier delivery, wasn't it? Was that the case?
The conference of the sites occurred on 1 February 2024, and the delivery date was on 27th of March 2024. Respondent applied for an import permit on 5 February 2024, so only 4 days after the conference. It took the reasonable effort in order to take delivery. However, on 14 February 2024, if the tribunal may follow me to page 57 of the problem, this is the procedural order number 2. On the 4th line, end of line, and I quote, on 14 February,
I'm sorry, you said 57.
page 57, paragraph 17.
Okay.
Sorry. On the 4th line, middle of the line, and I quote, on 14 February 2024, it was informed by the relevant Equatorian authority that no permits would be issued pending further ministerial guidance, end quote. Furthermore, respondent could not have taken an earlier delivery, as claimant has mentioned. If you look at paragraph 15 of the same page, placing the vanilla orchids in the old greenhouses would have led to the loss of more than double the number of vanilla orchids. Claimant also mentioned that respondent could have taken a partial early delivery. However, respondent would probably have still been held liable for not taking the other 2,000 vanilla orchids. Besides, claimant had never proposed this solution at the time, and respondent believed that it could still be able to take in full delivery of the vanilla orchids at the on 27th of March 2024. The second condition for an impediment is that it should be unforeseeable. Even if clause 1.1 mentioned the site's amendments, it is not the decision of the site that was unforeseeable, but it is the state intervention that was completely unforeseeable at the time of the conclusion of the contract. Appendix 1 is not self-executory and requires government intervention. This sudden change in government policy was unforeseeable. First, the regulatory environment was historically stable. Equatoriana had always maintained a favorable and even a generous approach towards the grant of import permits. As noted by the Bulgarian Chamber of Commerce and Industry in 1995, an impediment is foreseeable only if a ban had been experienced prior to the conclusion of the contract. In our case, there was no ban experienced in Equatoriana. Second, the timeline made foreseeability impossible. The Standing Committee of Sites recommended to move the vanilla orchids into Appendix 1 in September 2023, a full year after the conclusion of the contract in August 2022. Respondent was further surprised by the social media campaign in January 2024 that shifted the government policy suddenly. Finally, respondent had relied upon Article 15.1 of CITES, which, and I quote, states that amendments adopted at a meeting shall enter into force 90 days after that meeting for all parties, end quote. It was common knowledge that the conference of the sites would occur on 1 February and that the delivery would occur on 27 March, so within this period of 90 days. If the tribunal has no further question on the first submission, we will move to the second submission. I will inverse claimant's outline. First, we will demonstrate that Article 75 is inapplicable, and then, subsidiarily, should Article 75 be applicable, demonstrate that the damages should not have been calculated in the manner adopted by claimant. Should the tribunal find, contrary to our primary submission, that an impediment does not exist, then the conditions of Article 75 have not been met. The resale has not been made in a reasonable time and manner after the avoidance of the contract. Article 75 follows a strict mandatory chronology. There can be no substitute transaction while the contract is still legally in effect. This is supported by an ICC case number 7645. By entering into a contract with Herbal Cosmetics on 14 February 2024, 2 weeks before the termination of the contract on 1 March 2024, claimant has disqualified itself from this remedy. It could have waited until the end date of delivery in order to conclude the substitute transaction. By not waiting and rushing into this alleged cover sale, claimant did not conclude a reasonable sale. The CISG Advisory Council Opinion Number 8 requires that a merchant act as a prudent and diligent businessman, seeking to obtain the highest price possible. Claimant did the exact opposite. It rushed into a contract with Herbal Cosmetics and sold the vanilla orchids for $1,000 USD, half the contract price. Claimant could have used its broad network of clients in order to find a buyer who would be willing and ready to pay a higher price for the vanilla orchids. It could have entered into negotiations with other buyers, but it took no single step in order to mitigate the damages and is now expecting respondent to foot the bill. If the tribunal considers that Article 75 is applicable, then the damages should not be calculated in the manner it was adopted by claimant. Claimant is seeking $3,300,000 based on the highest quantity in the tolerance clause. However, it is the minimum quantity that should be taken into account. In international sales contract, where a tolerance clause exists, in this case it is the plus or minus 10%, it is considered that the quantity that should be taken into account was the quantity that the buyer was required to take and not the quantity that the seller had hoped to deliver. This is supported by case law. as held by the House of Lords in Bounch Corporation versus Tradax Export, in case of a substitute transaction that has been concluded, and in the presence of a similar tolerance clause, it was the minimum quantity that was taken into account. Claimant also mentioned, rightfully, that this tolerance clause exists to manage the unforeseen fluctuations in the growth of vanilla orchids. This does not give claimant a unilateral right to choose the highest quantity possible under the contract. Finally, the correct math leads to $2,700,000. The quantity that should be taken into account is the minimum quantity, which is the 2,700 vanilla orchids. It is 3,000 minus 10%. The price difference is 2,000 USD in the contract price and 1,000 USD in the cover sale. And this would lead to $2,700,000.
So if the liability is found, how do you suggest that the tribunal will quantify the damage under the CISG?
Could you rephrase the question, please?
If the liability is found, the tribunal found that there is a liability, how do you suggest that the tribunal will quantify the damages?
Respondent submits that the tribunal should take into account the minimum quantity in the tolerance clause and not the highest quantity as claimant has done. Claimant had mentioned that respondent had not determined the quantity of vanilla orchids before the transportation. Even so, it is not the highest quantity that should be taken into account. It is the 3,000 vanilla orchids that should be taken into account. In light of the above submissions, respondent respectfully requests that the tribunal find that it is exempted from liability under Article 79 of the CISG and Clause 12 of the contract, which explicitly mentions government measures as a force majeure event. Alternatively, if the tribunal finds that the respondent is not exempted from liability, to find that Article 75 is inapplicable and to dismiss claimant's request for damages in its entirety. If the tribunal has no further questions, this concludes respondent's submission on the merits issue.
Thank you very much. So we have one final thrust and one final pairing. We'll try to keep it to the 2 minutes. Go ahead.
Before starting, can I ask for something, please? I want to answer the last question that Mr. Arbitrator had asked me, which is for Article 25 CISG. Is it okay to answer that
Yes,
before the
go on.
button?
Fair.
Thank you so much. We here submit that in regarding of Article 25 CISG, the breach was fundamental as it resulted in a damage of 6.6 million. And according to Article 74 CISG, we here submit that the damages were actually foreseeable at the time of the conclusion of the contract. Moving on to the rebuttal. Members of this tribunal, opposing counsel, had wrongfully demonstrated the facts of the case. Well, in the case at hand, the CITES conference had occurred on the 1st of February 2024. And after 4 days, respondents applied for permits. So even with the government's measures and the CITES convention, respondents did not act in a business person. With that, respondents cannot be exempt from liability pursuant to Article 79(1) CISG. And with that, I conclude and thank you.
Much.
Respondent took all the reasonable endeavors to avoid the impediment. It had tried to see if an earlier delivery was possible, but as demonstrated before, it was not possible. It had applied for the import permit when it was required to. Before the inclusion of the vanilla orchids into Appendix 1, there was no need for an import permit. So respondent promptly applied for an import permit the minute the vanilla orchids were included into Appendix 1, and as such should be exempted from liability.
Does the Article 79 excuse liability permanently or merely suspending the performance?
Article 79 concerns, in this case, the impossibility to perform the contract permanently.
Okay, so at what point, if any, would the claimant have been actually entitled to terminate the despite the evident.
The end delivery date, according to the contract, was 31 March 2024. So claimant should have been able to conclude the substitute transaction after that date when it was clear that respondent would not be able to perform, and not before that date when it had not even given enough time to search for other buyers.
Comment on that?
Well, members of this tribunal, Article 75 should be applicable in a case-by-case analysis because the respondent's subsequent conduct, it indicates that they would not fulfill the contractual obligations when respondents contacted our clients on 10 February 2024. In light with Article 77 CISG, claimants mitigated its loss and entered into substitute transaction. And with that, I conclude.
Right. Thank you both. We've come to the end of your pleadings. Any last comments? The tribunal side?
Well, actually, I have one comment for the claimant, or just a question. If Article 75 is rejected, what is your alternative legal basis for damages?
We here for damages pursuant to Article 74 CISG, as the damages were actually foreseeable at the time of the conclusion of the contract. Members of this tribunal, logically speaking, when a party enters into a contract, it expects payments in order for an exchange for performance. So non-performance foreseeability causes damages. And in the case at hand, the foreseeability of the damages were actually foreseeable at the time of the conclusion of the contract. So in line of Article 74 CISG, claimant is entitled for the $6.6 million. Thank you.
Can I have just one last question? And you're when you are quantifying the losses, have you consulted any expert, for example, account expert, or to take other elements than just the bare difference? Other elements, other circumstances of the market, for example, fluctuation of prices?
Well, Mr. Arbitrator, I'd like to answer your question into two folds. First, in according with Article 75 and 74, my apologies, in according with Article 75, claimant is claiming for the difference between the substitute transaction and the sales agreement, which is the 3.3 million. And on the second fold, the market price of the March was 1,100 orchid flowers. And this is upon the tribunals. If they see that the substitute transaction is not reasonable, we should apply Article 76 CISG, which is the market price. In the case at hand, the market price was in the amount of $1,100. So claimant is entitled for the $3.3 million. Moreover, according to clause 9.2 of the sales agreement, it says that, and I quote, neither party is liable to indirect, incidental, special, or consequent causes, including loss of profits and anticipated saving, business, or reputation. End of quote.
Oh, I have one last question for
Okay.
in relation, if I can. So if the tribunal, this is for the claimant, if the tribunal were to apply the 2025 SIAC rules, what specific procedural prejudice would you suffer?
Mr. Arbitrator, if the 2025 rules were to be applied, then claimants would be subject to rules that had never agreed on, and this could lead to future issues in the enforcement of the arbitration award, especially in accordance with Article 5(1)(d) of the New York Convention, which states that
The question again, what specific procedural prejudice would you suffer?
the procedural prejudice that we would suffer is that claimants would be facing Article 38 of the SIAC 2025 rules, which it had never agreed on, and would be required to disclose its arbitration agreement if the tribunal sees fit. But here we submit that the tribunal should not see that it's fit, as there is not a necessity to order the disclosure. Thank you.
And for the respondent, how do you respond to the argument that applying your rule undermines party autonomy and also legal certainty?
It is our position that both parties have agreed on the application of the 2025 SIAC rules, and most respondent had in mind that the tribunal will have the power to order disclosure. So in absence of the application of the 2025 SIAC rules, the proof for the disclosure would be harsher, since the 2016 SIAC rules do not expressly provide for the power of the tribunal, but condition it to the necessity and the proportionality conditions as mentioned.
All right. Well, thank you very much for your presentations. I will take the opportunity to take 3 or 4 minutes to make some comments on what I've observed. We've been confronted with 4 absolutely excellent pleaders who will go far, I'm sure, in various places, not just one that you can concentrate on. So these are my observations. Ms. Saif, I enjoy listening to you. You're a lively advocate. I'll say 2 things to you, and the second one is very nice. First one, don't ever again agree with your co-counsel. When your co-counsel is speaking, it's not the time to go like, we know you agree with her. And that's to everybody. Don't do that. You have an excellent co-counsel. She knows what she's doing. She's doing it, and we know you agree. You can't help yourself. From now on, try to. Apart from that, your eye contact, you can agree with yourself all you want. Great enthusiasm, and you do, and it's engaging and very attractive. So don't. I'm just telling you one thing not to do. For all of you, be a bit careful when you want to trash your opponent's arguments. Don't traduce them. Don't state them in any other way than precisely the way they've been. So it's actually best to quote them. Don't put them in a way which is slightly more favorable to you and not so good to them. Put their case as strong as you dare, and then tear it apart. And that's the goal. You can't always do it, but that's the goal. 3, and there's only 1 more after that. A tip. Don't blame anybody for this. You know your case very well. Don't know your text too well. We all, some of us just start forgetting, but we all tend to know our case so well that we can bore our friends and neighbors who aren't lawyers forever as we tell them about our latest adventure. But when you're speaking to a tribunal which doesn't know the case as well as you do, don't know your text too well. If necessary, pretend not to know it so well, like you're sort of discovering it. Like, can you believe this? And you're enthusiastically, wow, look at this is what they actually say. Ask yourself a question and then answer it. The question you wish somebody would ask you. Okay? Play with the idea a little bit, and that will strengthen your presentations. And 4th, obvious tip, as you go forward in your life as excellent advocates, it's good to prepare little sound bites ahead of time. You know the difficult, you know what questions might be difficult, and actually prepare them, memorize them, and make them sound absolutely spontaneous. Ladies and gentlemen, that concludes the day. I think all of us have enjoyed seeing these performances. I hope all the advocates have found it as enjoyable as we have in observing you. And we, the members of the tribunal, now have some difficult discussions, but we congratulate everybody, but particularly the 4 finalists. So, who is going to tell me what happens next? That's allowed. Fatima.
Everyone leaves and deliberate and decide who is the winning team.
It'll be in the newspaper tomorrow.
Yeah.
That's cruel. Sorry,
At the ceremony.
at the ceremony. Okay, good. Thank you. You're the stars. I mean, get in.
We'll squeeze.
Maybe the tribunal sits down and they can stand behind the.
Oh, you can do that.
Yeah.
You like?
I think that'll be better.
You have enough space?
We
Okay.
just go stand in the back.
Sit down. I don't think there's enough space. Let's try.
There it is.
Can you squeeze?
Yeah.
You see?
Yeah. No. Looks like press conference more. Tell more.
Come back.
And we have to make a press release.